Olga Tellis and others versus Bombay Municipal Corporation, AIR 1986, SC 118. This case concerns itself with the plight of the pavement dwellers and slum dwellers of the Mumbai metropolitan city. In 1981, the state of Maharashtra and Bombay Municipal Corporation took a decision that all pavement dwellers and the slum dwellers or basti dwellers in the city of Bombay will be evicted forcibly and deported to their respective places of origin or removed to places outside the city of Bombay. Following this decision, some pavement dwellers were demolished by the Bombay Municipal Corporation. Some of the pavement dwellers challenged the decision of the Bombay Municipal Corporation and the state government in the High Court. Before the High Court, pavement dwellers admitted that they could not claim any fundamental right to put up huts on pavements or public roads, and also gave an undertaking or assurance to vacate the huts on or before 15th of October 1981. On such assurance being given, the Bombay Municipal Corporation and the state government agreed that the huts will not be demolished until 15th October 1981, and the writ petition was disposed of accordingly. But a writ petition was filed before the Supreme Court under Article 32 of the Constitution of India by a journalist, Olga Tellis, and two pavement dwellers whose establishments were demolished after an order of eviction and deportation of slum and pavement dwellers passed by the government of Maharashtra, citing the Bombay Municipal Act 1888. Subscribe the channel and hit the bell to not miss any update. A second group of petitioners whose plea was heard along with this petition belonged to two different slums and challenged that attempts were made to deport them from their place of settlement, even though they had obtained an order of injunction restraining the officer of the state government from carrying out the directives of the to evict them from their dwelling places. The People's Union of Civil Liberties, Committee for the Protection of Democratic Rights, and two journalists have also joined in the writ petition. Writ petition filed under Article 32, the petitioners challenged the decision of the Bombay Municipal Corporation and the state government on the ground that, firstly, that evicting a pavement dweller from his habitat amounts to depriving of his right to livelihood, which is comprehended in the right guaranteed by Article 21 of the Constitution, that no person shall be deprived of his life except according to the procedure established by law. Secondly, that the eviction order of the state government and the Bombay Municipal Corporation is violative of the provisions contained in Article 19 and Article 21 of the Constitution. Thirdly, that the procedure prescribed by Section 314 of the Bombay Municipal Corporation Act 1888 for the removal of pavement dwellers from pavements is arbitrary and unreasonable, as it does not provide for giving of a notice before the removal of a dwelling. It means they can remove a pavement dweller without notice. Fourthly, that it is constitutionally not permissible to characterize the pavement dwellers as trespassers, as only because of economic constraints they are occupying pavements. And lastly, that the court must determine the content of the right to life, the function of property in a welfare state, the dimension and true meaning of the constitutional right that property must promote common good, the scope of the right to reside and settle in any part of the territory of India, which is guaranteed by Article 19(1)(c), and the right to carry on any occupation, trade or business which is granted by Article 19, Clause 1, Subclause G, to settle the competing claims of pavement dwellers on the one hand and of the pedestrians on the other hand, and the larger question of ensuring equality before the law. This writ petition was filed. Question of law. Firstly, whether within the ambit of Article 32, an estoppel can be obtained against the enforcement of fundamental rights. The question of estoppel arose as because some petitioners agreed before the High Court that they do not have right to live in the pavements. So, the Supreme Court had to decide whether estoppel can be enforced for fundamental right. Secondly, whether forcible eviction and uprooting of their settlements deprives slum dwellers of their livelihood and consequently of their right to life as granted by Article 21 of the Constitution, and is further in violation of their right to occupation and right to settle as given in Article 19, Clause 1, Subclause C and Article 19, Clause 1, Subclause G of the Constitution of India. Thirdly, whether the law as laid down in Section 314, read with Section 312 and 313 of the Bombay Municipal Corporation Act, which empowers the municipal commissioner to remove any object or structure set up on any street without notice, is reasonable, fair, and just. Decision of the court. Firstly, the court held that the petitions were maintainable under Article 32, which gives a citizen the right to approach Supreme Court directly in the case of violation of a fundamental right. Supreme Court further held that no estoppel can be obtained against the enforcement of fundamental rights. The court, in this regard, stated that no individual can give away the freedom conferred upon him by the Constitution. A compromise made by him in a proceeding, whether under a mistake of law or otherwise in any other way, he does not possess or will not enforce any particular fundamental right. That assurance cannot create an estoppel against him in that or any subsequent proceedings. Such compromise by him, if enforced, would defeat the purpose of the Constitution. The next question that the court addressed related to Article 21 of the Constitution of India, which reads, "No person shall be deprived of his life or personal liberty except according to the procedure established by law." In this regard, the Supreme Court clearly stated that a right to life would be meaningless without ensuring means of livelihood. Thus, it is made clear that without means of right to livelihood, there can be no right to life. The Supreme Court held that no person can live without the means of livelihood. It means if the means of livelihood is not treated as a part of the constitutional right to life, the easiest way of depriving a person his right to life would be to deprive him of his means of livelihood. Giving consideration to the plight of the pavement and slum dwellers and the economic compulsions that force them to lead a poor life, the Supreme Court further held that the right to occupation provided under Article 19, Clause 1, Subclause Z, as well as the right to settle provided under Article 19, Clause 1, Subclause G, have been violated by the Bombay Municipal Corporation Act 1888, as this act has provision evicting the pavement dwellers from their place of living and thus cause a disruption to their occupation. The pavement dwellers are living nearby to their place of work. The pavement dwellers choose to live nearby to their place of work as because it saves a lot of their money from transportation, which they could not afford if they were to live places far away from their place of work, and thus evicting them from there will act as a depriving them from their work. The court in this regard held that if there is an obligation upon the state to secure to the citizen an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of the right to life. Coming to the second part of Article 21 regarding the procedure established by law, Section 314 of the Bombay Municipal Act was in fact valid law and not unreasonable, as it was only an enabling provision and it is not a compulsion. It means that under this section, an officer is not bound to demolish any object which is set up on the streets, but it gives a power to the officer. If the need arises, the officer can demolish any object set up on the street without notice. In this regard, the court specified that such a need had to be judged carefully and exercised only when no other option was available. In the current case, the Supreme Court said that a right to be heard must be given to the pavement dwellers. A notice must have been served before the eviction. In the light of this, in conclusion, the Supreme Court passed an order of eviction, but the Supreme Court ordered that the person who are to be evicted must be given a month's notice. Along with, they must be given suitable alternative place to live in. Thank you so much for giving me your valuable time. I hope you liked the video. If you have any doubts, do let me know and I'll try the best possible way to clear those doubts. Do subscribe the channel as I'll be posting regularly such law contents. Till then, I'm Ricky signing off.